Hi, good morning. Thank you for joining us for this CLE presentation by our MCLA's Executive Director, Bennett Root. Thank you so much, Ben, for taking your time to present for us. Not only is Ben our Executive Director, he is a highly experienced and trained attorney, mediator, and arbitrator with years, I won't say how many, but many years of experience. Ben graduated from Harvard University with a JD and received his LLM through Pepperdine. He specializes in business, commercial, employment, startups, and community law. He is also commissioner on the Los Angeles County Mental Health Commission. So we're going to wait just a couple more minutes so everybody can join, but a couple of things. You will receive your certificate of completion via email once we receive approval from the state bar. So the email that you're registered with, that's the email that the certification will go to. You'll also, at the end of the presentation via email, receive a survey. So we hope that you will fill that out. We'll leave about 5 minutes at the end of the presentation for questions and answers. But if you also have a comment afterwards or a question afterwards, you can email us at events@mediationla.org. Okay, Ben, you could take it over.
Good morning. I'm Ben Root. I want to thank you for joining this webinar. Our program today really focuses on designing a winning strategy for successful mediation results. And this is premised on a simple but I think very important concept, and that is this. Careful preparation for mediation is as important as careful preparation for trial. Developing the strategy and tactics for mediation maybe doesn't take as long. And of course, it relies on common elements as trial preparation, but the process is very different. So the strategies are often different, and the preparation needs to be different in order to get the best results possible. So that's what we want to examine this morning. Before we get too far into the weeds, let me share my own perspective, because often where you stand on various issues depends on where you've been. I've spent several decades practicing law in Southern California, sometimes a little different than some of my partners, but I worked, for example, in developing new patterns for collective bargaining where old patterns simply weren't working for people, and we were losing jobs overseas and otherwise undermining our business right here in California. I developed a number of corporate dispute resolution programs where businesses were spending more money than they wanted to on conflict and disputes, and we needed to get that under control. I did a whole lot of arbitrations and mediations, many of them in the employment and civil rights area, but not all. And I've done some civil unlimited litigation, both on the plaintiffs and defendant side. So in that process, I've seen a lot of different elements where disputes are brought to the center and need resolution. After kind of completing several decades of practice, I did go to Pepperdine for their dispute resolution program and got my LLM there, concentrating on dispute resolution. But that's not the only trainers. I've also done the Harvard PON program, and I'm Cal DERPA certified. And most recently, I've served as the executive director at MCLA, which services the Los Angeles Superior Court, one of the largest courts in the country. Last year, we did about 1,200 cases for the court. This year, we'll probably double that, or close. But most significant in the cases both that I've handled, analyzed afterwards, and in some of the cases that I've supervised or worked with other mediators on, the question is really, have we achieved optimal results? And I think in many of those 1,200 cases, we have underperformed optimal results, usually because the advocates in the mediation process were really not well prepared for the mediation process and how it differs from litigation. So let's look at that for a moment. If we just look at the very essential difference between mediation and litigation, look to the decision makers. Who is making the ultimate decision? In mediation, the decision whether to accept or reject a position depends on the agreement of your opposing party. In a courtroom setting, obviously, a judge looks at this through the eyes of the codes and the cases, and the jury looks at it through the jury instructions. So what we see here is that in mediation, our job as an advocate is to induce results, that is, induce agreement from the other side. In litigation, very different job. We're supposed to convince the trier of fact that the law is on our side, the facts are on our side, and they deduce the result in a fairly structured setting. The second major difference, very important to keep in mind, is that in mediation, we can create all kinds of remedies. In a courtroom setting, again, there are prescribed remedies. We're bound by the codes, we're bound by the cases, we're bound by the jury instructions. So they kind of restrict and define what we can do. Not true in mediation. So the thoughtful advocate can come up sometimes with some very creative results that are highly beneficial to his client and really improve the results in a mediated context over what they might expect in a courtroom situation. So it's these two things that I want to keep in mind as we go through our discussion this morning. Now, looking at the mediation process, there's a fairly determined and set up number of steps that attend each mediation. They're different for each mediation. The details are always very important, and the devil is in the details. But the basic steps involve first engaging and establishing trust. Obviously, you want to have trust with your own client because they're coming to you for counseling and advice. But you also want to establish trust with the mediator, not necessarily that someone's going to agree with your position, but that they trust what you say, the representations that you make. And this is equally true for opposing counsel and sometimes for the opposing party as you get into discussing interest. Remember, you're inducing results here, not deducing results from a third party. So this trust turns out to be important, even if people don't agree with your propositions, they need to trust you and what you say. The second thing that's critical is decide who are the solution buyers. That's a strange term in a litigation context. But in mediation, we are able to craft our own solutions, as I said in the slide previously, not restricted by the teachings of the remedy class that we took several years ago. So we can craft our own solution, and we have to decide who it is that is buying into that solution. Very important point. We'll talk about it in a little more detail as we go through, but I regard it as the second step in a mediation agenda. Usually the third step is going to be to reframe the interests and focus not so much on technical legal positions, particularly pled in the alternative. Sometimes we may have 5 or 6 different ways that we think we can get to a result that we're looking for in a litigated context. But in mediation, we actually look at the interests of the parties, not necessarily their positions, and we'll talk about how those are different. And oftentimes it'll fall on you as the mediation advocate to reframe the discussion away from positions and into what are the interests of the parties in going through and proceeding with the mediation. This often gives us the opportunity to look for a solution by using a Venn diagram. Those are those three circles that intersect. We'll look at it in a little more detail in the next slide. But a careful analysis of where the overlaps are indicates usually where the sweet spot is of the mediation. So I think this is an important step that will attend virtually all the mediations that you do. The fifth step in successful results in a mediation is selling the decision or getting buy-in for the solution by the other side. The mediator's opinion doesn't matter a whole lot because the mediator doesn't have any real power here. It's the other side. So the fifth critical step is selling the decision or the solution to the decision makers on the other side. And finally, important is documenting the solution that you've seized upon, knowing whether it's going to be completely confidential, partly confidential, whether the court's going to retain jurisdiction for enforcement over a period of time, etc. So these are the 6 steps that I believe will attend almost all mediations and will help guide you through setting your own strategy. I mentioned Venn diagrams. There's a classic illustration up in the upper right-hand corner. But what we really need to look at to make a Venn diagram work, or thinking through the same thing in a mediation context, is what are the distinct interests of each decision maker? Basically, there are usually 4 decision makers in a mediation, and sometimes there are more than that, or sometimes many more. But the 4 basic decision makers usually are plaintiff and plaintiff's counsel. You might be one of those. Defendant or defendant's counsel. Those are the basic 4 that are usually involved. And then there are sometimes others who may or may not be in the room, but are in the process. Family, friends, professional colleagues. There are perhaps others that are involved. Insurance companies in a personal injury case sometimes have distinct interest from the parties themselves, so they would be an additional decision maker. And the point is that each of those decision makers has a somewhat different perspective and interest in the results here. Plaintiff is looking to get something. Plaintiff's counsel is looking to get something too, but it's different than plaintiffs. And similarly, as we go through the decision makers. So the diagram on the left, the colored diagram on the left, there is an example of a Venn diagram looking at 4 elements with different characteristics, in this case, fire, earth, water, and air. And as you work through where those interests overlap and what it means, when you get to the center of the Venn diagram, you've got an idea of what the sweet spot will be, where you're trying to get to, because you have satisfied the various interests who are the interest of the decision makers, the people who need to be induced to make an agreement. Now, in looking at interest, there are a varied number of interests for those decision makers. We tend to default to and think about monetary interests. But there are also a number of non-economic interests. We'll talk about some of them, but for example, speed of resolution, relieving stress of conflict. These are non-economic interests, but they're very significant interests. Additionally, there are sometimes going to be equitable interests that may be a little bit different than the first two, monetary and non-economic interest. And time and certainty issues attend. Mediation gives the opportunity to resolve the uncertainty of litigation and speed the results. So these various interests have value, and the question is to whom and how much when we try to find the center spot on the Venn diagram. So there's some information that I believe advocates in mediation need in every case. Let's go through what those are. First, as we were talking about on the previous slide, will be the interests of the various decision makers. So once you've identified the decision makers, it's worth taking time to brainstorm and think about what are their various interests. I've listed a handful of them, but the list is long, limited only by creativity. But the time value of money is also often very important. Relieving stress, I mentioned. Conflict is stressful. Maintaining a lawsuit is stressful. It interferes with our life and our other life objectives. Eliminating that stress often has value. Usually there are opportunity costs, time and resources that are invested in litigation can't be used other places. So you get to proceed with the litigation, but you have to give up other opportunities. There are funding costs sometimes. Sometimes these may be handled through contingency arrangements. Sometimes they're not. It's important to think about that. There are reputational costs from proceeding or settling. These are interests that should be thought about. What I call the future is now, to some extent reiterates what the opportunity cost is. The point is that mediation gives us the opportunity to truncate the dispute resolution process, and that oftentimes has value. And then there are any number of specific case-dependent interest that a party may have. Sometimes there's specific performance involved. There are any number of items that may come out of the case. Now, each of those interests has a valuation, and I suggest that it will be helpful to you to consider, perhaps not precisely trying to calculate the valuation, get an idea of what the time value is of money, what the funding cost, reputational cost. These interests may have value, positive value or negative value to a particular decision maker. And as you try to induce agreement from that decision maker, understanding these interests and talking with the individuals about it becomes very important. How you are going to introduce these interests is also important. It's kind of like how you're going to introduce the evidence. Do you have a foundation? There are 100 other questions that we've all dealt with. But introducing interest is a little bit more delicate. Sometimes you can't suggest it directly, and you may want to use the mediator. We'll talk about some other techniques, but introducing interest and shifting that focus is what I called reframing previously, and advanced thought and preparation about how that is going to be done will pay you very substantial dividends. And then last in this column is once these are introduced, there will be an external evaluation by the other side or the party who's interested. Might or might not be similar to your thought about what the valuation is, but getting an idea of how the other side values a particular interest will be helpful to you in crafting the benefit, the bucket of benefits, for lack of a better term, that makes up what you're using to try to induce agreement to the solution that is being considered in mediation. The second big and critically important information that you will need in a case is, what is your BATNA? BATNA is an abbreviation of the best alternative to a negotiated agreement. If an agreement is possible, hooray. If it's not possible, what's your client going to do? And looking at that alternative, or sometimes there are multiple alternatives, but you want the best alternative to a negotiated agreement. What are the demands that will be placed on your client if there is no agreement? What are the costs that will have to be borne if there is no agreement? What perceptions may flow from there being no agreement? And how is the alternative, whatever it is, might be continuing the litigation, could be abandoning the litigation. There could be other things that will be done, but it's important to look at what that alternative is. And then there will be a time that it's important to communicate to the mediator, perhaps to the other side, what that BATNA is, because it will determine when you stop the mediation or whether you're able to press ahead for an agreement. Third area where you're going to want to have thought about and planned for things are what mediators usually call ZOPAs, or the zones of possible agreement. And these vary depending on whose position you're standing in. Your client's going to have one viewpoint, the other party's going to have a different viewpoint. Mediator might have a third viewpoint. But basically, this is a range of possible settlement alternatives. Sometimes it could be dollars, 100,000 to $250,000, or 5 million to 7 million, or might be 50,000 to 60,000, depends on the nature of the case. What is the range where there is it's possible agreement, has a low, has a high? What is that range? And then once you've looked at it through different perspectives, the clients, the other parties, maybe the mediators, you can decide whether there are overlapping ZOPAs, overlapping zones of possible agreement, or whether they're non-contiguous. Your strategy is different depending on whether they're overlapping or non-contiguous. So it's important to know those things. Now, the use of the critical information that we've just looked at will depend on where we are. When your BATNA is within the zone of possible agreement, hooray, the case should settle if you've assessed it correctly. And then certain benefits will attend to the various decision makers who have an interest in the dispute. Sometimes your BATNA exceeds the ZOPA ceiling. When your BATNA exceeds the ZOPA ceiling, you have a problem. And it's probable that mediation will not be a good solution for your client, and a mediated agreement may not be possible. This may be the time you want to communicate your BATNA, at least to the mediator. Most mediators want to settle cases. So if they believe the case is not in a posture for settlement, they may need to recalibrate, use different tools. We'll talk about those in a few moments. But this should set off alarm bells when your analysis of the case indicates that your BATNA exceeds the ZOPA ceiling. The third possibility is the opposite of this. It's a very happy possibility. When your BATNA is less than the ZOPA floor, remember the ZOPA is a range, when your BATNA is less than the floor, there is an opportunity for significant gains in benefits to your client. And in this happy case, the question is how you employ your skills, your strategy, your tactic as you work through the mediation to get to the highest and best solution for your client. But now you can see how having these numbers allows you to shape the possibilities as you go forward, depending on how the numbers work out. Now, given that preparation, the question then is, how do you make the mediation process work for you? And there are a number of steps and possibilities we'll talk about, but let's start out with these to get oriented here. The first is, I think, in mediation, it's very important to keep the dialogue going. And you want the dialogue to be as rich as possible. Sometimes a mediation settles in relatively quickly to, I'll give you one number, I get another number from the other side, we think about it, we pick another number, and we lose sight of the other benefits that are part of the bargain. I think this is oftentimes a mistake to narrow that discussion. We want to, I think, look at all of the benefits of a solution that accommodates various interests because there is value in those things, and we need to keep the total value, not just the monetary value, front and center. So the richer the dialogue, generally, I think the more you're likely to focus on solutions and a mediated settlement result. Second thing is getting the other party, to adopt your ideas. This is great because ultimately we usually trade value in making a deal and a mediation. So if you can get the other side to invent the idea that you think is important, you don't have to give anything away in the trade. They've already invented it. So there is a lot of benefit here to planting seeds early. I expect this is going to be important to your client. That can be explored offline before the mediation. There's a lot of freedom in mediation that doesn't necessarily attend a litigation. We'll talk about that too in a moment. But getting the other parties to adopt your ideas, or even the mediator to adopt your ideas, can be very useful so that you maintain as much capital as possible when the ultimate trades need to be made. The third thing to give some thought to and plan for is making the mediator work for you. The mediator can be oftentimes is very good at sending messages to the other side. Oftentimes, the mediator can help you get information that you may need. You're getting stonewalled in discovery. You're not getting the documents you want. There are a list of objections as long as you're armed to those interrogatories. And oftentimes, the mediator can talk to the other side and say, look, you're going to have to give this up. Ultimately, if you want to reach a mediated settlement, let's provide the tools. There are some general rules about mediation and disclosures not nearly as formal and certainly not binding the way they are in litigation. But both in planting ideas, that is the sending of messages, and the securing of information, the mediator can do a fair amount of work for you. And we'll talk a little bit more about how to ask for that. But it's important to ask for it because when the mediator does it, sometimes the answer is very different than when you do it in a litigated context. Fourth element to look at carefully will be what I call managing the clock. There are three elements generally to any mediation: your opening, your middle game, your end game, or closing the deal. I think that's important where you're looking for a result in mediation. Might be a settlement. Hopefully, it's a settlement. Sometimes it's something different. You're really looking for information. You want to assess how the other side's going to be as a witness, or how they're going to appear to a jury, or there are a number of different things that are done in mediation. So it's not always just about the settlement. Sometimes there are other valuable elements. And in managing the clock, whether you have a lot of mediations in Southern California are premised on a 3 or 4 hour bracket, sometimes all day, sometimes they um, uh, go on for multiple days, depending on a whole bunch of factors. We'll talk about that as well in a moment. But I think it's important in the opening to express the fact that you're there to reach a mediated result. You're there in good faith. If you come in and you're crossing your arms and generally being difficult to reach or communicate with, in a classic power position, it may send the wrong message. So the opening is very important, and I urge you to give some thought to it and express your interest in reaching an affirmative result in the process. Um, the middle game is different. This is the exchange of information. This is setting the foundation for the agreement later on. This is introducing interest and reframing interest as opposed to positions as the determining factors that decision makers should be looking at. May go on for several hours. The mediator can be heavily involved here, but you need to, in my mind, consider what information do you not have that you need? What information do you need to give the other side so they can make the decision you'd like, or at least a decision in the range that you'd like? How does that play out? In what order? All of these things are as important as thinking about the order of presentation of witnesses in litigation, because that's kind of what you're doing. You're telling your story by releasing information in the middle game, securing information, reacting to information. And then the third part is end game, or I call closing the deal. How do you start to pull this together? Now, it may occur to some of you that what I'm talking about is a fairly active role for the mediation advocate. Sometimes people just approach mediation by sitting back and saying, the mediator should do all that. I don't need to do that. I'm just here to, see what the mediator does. He or she is supposed to be good at doing these things. That's true. But it cedes control of the process to someone other than you. And my point is that I've found over the years, both as a mediation advocate and as a neutral in mediation, that some advocates are very successful because they use the opportunity to be heavily involved on an affirmative basis, oftentimes drive the mediation. Where that's possible for you as an advocate, I suggest to you that you will generally get very superior results. Last point on this slide. Sometimes we're able to do things in a single session. There's a lot of value to coming together and working intensely towards a solution. But sometimes that doesn't work. Sometimes interim steps need to be taken. Sometimes it's the deposition. Sometimes logs need to be answered. Sometimes we need to do some private investigation. Sometimes ideas need to marinate with a client, or things need to be checked out. So the question is, do we need a follow-up session? Can we conclude this successfully today? As an advocate, you're going to want to think about how tired people are, how capable they are of thinking. And again, this is part of managing the clock. Do I need to call a timeout? Do I need to ask for a follow-up session? These are all the tools that make the mediation process work. We'll talk about some others momentarily, but these are part of setting strategies in mediation. Now, in terms of talking about setting strategies, I want to talk about setting the stage for a successful endgame. I believe there are several things to be thought about and cranked into your thinking as you look at strategy and tactics. First one, clearly, is establishing clear objectives. What are you trying to get out of this? What is in your client's best interest? Not necessarily their position. What is in the client's best interest? Once you've done that, you can get a stake in the ground. It's pretty well established that the initial stake in the ground has a very significant effect on the ultimate results. Some people conclude they don't want to put too much money out because it may shift the shifts or the ultimate result shifts the middle ground. And there's some reason to think about that. There's some counter arguments that we're going to look at momentarily. But getting that initial stake in the ground is very important because it starts to set the boundaries within which the case can come to its end game, to its resolution. And then you consider how are the parties going to move from those initial positions, the stakes in the ground, to the desired result. Sometimes it's a tennis match. I offer a nickel, they propose a dime. I offer 15 cents and, moves back and forth and stuff. Sometimes you need to induce an agreement that's outside of the middle ground, and that needs to be prepared. You may have come in with a somewhat higher offer than you might like to keep people's heads in the game, but you may not have a whole lot of flexibility. You may not be able to get to the classic middle ground, split the difference, whatever. And how you do that, we'll talk about as we get to the principles of influence momentarily. But it's important to give some thought to that. And sometimes you need to induce an agreement that may be outside of what is perceived as a fair result. Of course, fair is in the eyes of the beholder, and I think that the correct analysis here is how much value is being obtained or conceded, not some outside concept of what's fair. Understanding these are important as you craft your positions. So let's look a little bit because you have to induce the decisions of people that come in hostile to your position. Let's look for a moment at the art of persuasion. Classic study on this is done by Dr. Robert Cialdini. I commend his work to you. It's really excellent. And remembering that the goal here is to persuade the decision makers on the other side. You have to sell the solution that you want, the bundle of benefits, whatever it is. The question is how you do that. These 7 concepts have been found by Cialdini through a fairly good amount of documented social science work um, to be critical to inducing agreement. They're the principles that we all use here. These are the 7 that are called out by Cialdini. I tend to regroup these into 3 bigger groups. One is a group that turns on fear or power, and they're the principles of authority and scarcity that we'll talk about briefly. And then there's what are the honey principles, the sweetness here, the attraction principles, reciprocity, likability, and unity. And then the third group in my mind are the thoughtful principles. We deliberate, we look at how committed the other side is, what is the proof that this is a good idea um, as we go forward. So I think that all of these principles are usable. It's not really a question of whether you catch more flies with honey than vinegar, although we've all heard that from time immemorial. I think all of these principles can be effectively used. So there are some really good materials on Cialdini, including some done in much greater depth than we can do this morning by my colleague Myra Sankari. Um, um, but I think that the Cialdini principles usually flow in a particular order for mediations. The first is likability. It's easier to work towards a deal with people who are likable. Again, that doesn't necessarily mean you agree with their uh, their positions, but dealing with them from a likable standpoint helps. Second is the principle of reciprocity. That is, if we give something away, oftentimes our social conventions indicate that something should be given back. If you get a gift, you send a thank you note. There's a lot of exchange here. So I like to give careful thought to that initial stake in the ground and use the principle of reciprocity, that it's not just a token, it's not just the $5,000 that defendants throw in all the time to indicate how powerful their position is. And it's a point of getting something started, a meaningful discussion that keep the dialogue going point that I made earlier in mediation. So reciprocity is a hugely important principle, and I believe it belongs at the beginning of the process. Social proof is just indication that the solution you're providing isn't way out there. It's not on Saturn or Pluto or something. It makes good sense. Your commitment to your position is important for the other side to appreciate. Sometimes, as you get near the end here, authorities really help. And authorities could be any number of things, but court authorities obviously are important because we need to look at the alternatives if mediation fails. But also authorities that come from other positions where they know what things are, other settlements in similar cases or things like that. The 7th of Cialdini's principles is unity. I've got it 6th here. And that is that the solution that's being provided does make sense to a unified group of people. It's not something that's way out and very drastic or radical. And finally, scarcity. I believe that oftentimes this order of use of Cialdini's principles will serve you well in the mediation. Some mediations, you're going to vary these. Some mediations may not use all of them. That's the point. You want to think about it in advance and then take a look at Cialdini's work or look at Meyer's program on Cialdini, or there's a recent article in the Harvard Business Review on Cialdini and how his principles work. All of those are good resources so that you can wire this in to the discussions that you have with mediators, with the other sides. Finally, there are a couple of techniques that I want to hit on, and then want to leave some time for questions. There are two opportunities that you have early on to communicate with the mediator, and oftentimes this helps influence how the mediation proceeds, make sure that you're not wasting time, and often plants the seeds of success that you've worked out in thinking about what the critical numbers are, where your BATNA falls in relation to the zone of possible agreement. What the zone of possible agreement is. People come into mediation sometimes not having thought about that, including sometimes the mediator. So these are opportunities in pre-mediation conferences and briefs to take a look at that. A pre-mediation conference is usually just that. It's a kind of a readiness conference, a status conference, a case management conference. Lots of different titles for it in a litigated context. Very similar process here. Are you ready to go to mediation? Will you be ready at the time of the mediation itself, maybe 2 or 3 weeks after the pre-mediation conference? Do you have enough time to get all the things that you need? This is a time, mediation conferences, by the way, oftentimes are 15 to 30 minutes, so it's not a particularly big commitment of time, and usually it's just counsel and the mediator. But it is your opportunity to educate the mediator before the mediation, and usually before briefs are to ask questions and things like that. So in the mediation conference, oftentimes the general path for the mediation is discussed. This could be, do you proceed in individual breakout sessions or caucuses? Do you proceed in joint sessions? Are there reasons that the parties should be together, or more important sometimes, are there reasons that the parties should not be together during the mediation? Sexual harassment suits are oftentimes where we elect not to have the parties come together because going back through the initial injury often makes things worse and sets mediation back. Those are the kind of things that can be discussed and resolved in a pre-mediation conference and save a lot of angst, difficulty, and save the critical mediation time for the mediation process. So setting the general rules is important. It's also a great time to look at getting information that you may need. And sometimes you need to talk with the mediator and get the mediator to carry the water for you. But there sometimes, oftentimes, discovery is either not been attended to, or it's incomplete, or has been resisted. We all know that ultimately it's going to come out, and a lot of us are busy and haven't attended to these things. But this is the time to ask for things and enlist the mediator's help to secure the documents, information that you may need. Might be that a critical deposition really should be completed before the mediation occurs. This is the time to discuss that. It might be that you need to, after a pre-mediation conference, somebody's going to need to go back to the court and ask for some extended time so certain processes can be completed in order for the mediation to have the best chance of success. All of these things are things that the mediator can and should discuss with counsel. Um, uh, Interesting data point, again, from my colleague, Myra Sankari. In cases where pre-mediation conferences occur regularly, the settlement rate is much, much higher. And partly that's a function of uh, people being prepared for mediation. Don't schedule mediations for which you're not prepared. They can sometimes have um, unintended, seriously bad consequences. Um, so this pre-mediation conference, a time to just talk candidly with the mediator, um, I think is very helpful. And the data tell us that where this occurs, where counsel take the time to do this, sometimes insist on it, it's increases the chances that the mediation will be productive, useful, and the settlement rates are very significantly higher. Lastly, this is the opportunity to look at the process of joint meetings, caucuses, other sorts of things, whether witnesses are going to be involved. And sometimes it's an opportunity to think about who needs to be in the room. Um, it's my belief, both as a mediation advocate and as a mediator, as a neutral in mediation, that having the decision makers in the room is really helpful to success. Having the mediator, having the decision makers available by phone is better than nothing um, because they're at least available. But having them participate in the mediation is usually the better result if you can do that. So sometimes that may be a spouse um, or a trusted friend. Sometimes it's a professional colleague. You know, we said there were 4 distinct points and decision makers usually in mediation. If you have someone with a high bar number that needs to get permission to move outside of a particular range of settlement or add an element to settlement, it's helpful to know that there's access to somebody else to consult with. If the insurance adjuster is going to need to have access to his or her supervisor, uh, excuse me, it's helpful to know that. The pre-mediation conference is the time to work that out. And I put over on the right-hand side, NB nota bona, ex-parte communication in mediation is okay. Not okay usually in a litigated context, but it's okay because oftentimes a mediator will have confidential communications with one side or another. So ex-parte communication is okay and regularly used, and it is a tool for you to help sell your strategy, sell your desired zone of possible agreement, all of these ideas to the mediator, sometimes to the other side. Um, so consider how those communications occur. Secondly, briefs are very important. Good session coming up soon on mediation briefs through the Beverly Hills Bar for those that participate in their educational outreach programs. But let's just focus on this briefly and then we'll wind up and leave some time for questions. Um, uh, the briefs allow you to set your boundaries and discuss why those boundaries exist. The brief gives you an opportunity to get the mediator to think about what it is that you're advocating and influence the mediator and direct the settlement discussions. And I would urge you to work in your briefs to establish not only settlement discussions and the history, but where and how you'd like to see settlement discussions go. This gives the mediator a chance to let your ideas marinate in his or her head in advance, and it will help you, I think, a lot. Use your time efficiently in mediation and use your time successfully. Want to just identify some tactics that need to be employed on the fly. We don't always know how mediation works out, but this kind of falls in the category, if you don't ask, you don't get. You can always ask the mediator, what's he thinking? You can ask for the mediator's help. You can ask for private caucuses where you want to talk just to your client or go talk to a colleague or something like that. You can ask for a joint session when you want to assess where the other side is or make points or other sorts of things that you want to make sure are conveyed in the spirit you intend them. Oftentimes you can ask for attorneys only caucus, and these can be very productive. Sometimes we have client to client meetings where the attorneys are excluded. We had one recently, a commercial dispute, high value commercial dispute. The two CEOs got in a room together and with the mediator kicked all the counsel out, and they had a result in half an hour they were very used to and very happy with. You can also ask for or give an apology. An apology we haven't talked about, but they're sometimes hugely important to get over the issues. The interests really are more emotional than rational, and an apology sometimes will allow a lot of things to be cleared away. Sometimes you can ask for a public statement because mediations are confidential. This is an important thing to consider in advance. You can ask for your docs or your deliverables, and you can ask for follow-up sessions. So these are all things that you may want to employ as you go through in order, particularly if discussions stall and you need to get things done. So this leads me to what I've called the mediation workflow. And basically, we assess the client's interest first, usually, then estimate what we think the other party's interests are. Where possible, we expand and reframe remedies. So the bigger the pie, the more there is to go around. And we establish the desired settlement range, BATNAs, and SOPAs. Once we've done that, we can prepare a mediation brief or a pre-mediation conference that's really focused on the result we want. And we can establish a zone of possible agreement in the mediator's mind, sometimes at the pre-mediation conference. And if you can do that and it's consistent with your own zone, this will help you in your strategy. Finally, we integrate the Cialdini persuasion principles into our communications, consider what order to use them. So having done that, thank you. I ran a little bit longer than I wanted to. Sorry about that. Happy to entertain any questions. I'll put my contact information in the slides. If we don't get to the questions, happy to talk with you offline or by email. So, Crystal, do we have any questions that people like addressed?
Yeah, give a couple of minutes. You could either raise your hand and we could allow you to talk, or you could put it in the Q&A chat and we'll answer it there. There was a question that says, will these slides be available to participants after the program? So the video will be available for review. It's going to be on our website and YouTube. It's not determined yet whether or not the slides or a version of the slides will be available, but if they are, they will also be on our website along with the video. Oh, thank you, Karen. She said, very well done and quite helpful. Jeffrey said, do any of these principles change with in-person mediation versus Zoom remote mediation?
When difficult cases, particularly cases that involve emotion, I think are more likely to be resolved by in-person mediation. We do them some of the time. The trend is for Zoom mediation because it's easier, but in-person mediation helps keep people both literally and figuratively in the room, in the process. And in particularly tough cases, I believe there's value to that. And I guess the question is, do the principles change? Yes, you have a greater ability to actually use the principles where you can get in a small caucus room and talk to somebody directly. So from trust, reciprocity, scarcity is this goes away if we can't settle this today. We're back in litigation and it may not come up again. That's why I use it at the end of a mediation. Yes, all of those things are going to be influenced where you have the opportunity to actually sit with somebody and work on them.
Okay, we don't see any other questions. So again, if you do end up having questions or comments, you could email us at events@mediationally.org or even at info@mediationally.org.
Great. Thank
Okay.
you all for joining us this morning. Hope this was helpful. Happy to talk with you. Inevitably, questions tend to come up 2 days down the road. Send me an email or give me a call. Happy to talk with you. Thanks so much for this morning.
Thank you all.